Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, aka Bob, is a personal injury attorney in Atlanta. On today's episode, Bob tells you how to get into law school.
You can get an LSAT prep book.
Irreverent D makes a confession.
I just can't lie.
No!
Bob tells you how to work a courtroom.
I object, Your Honor. It's bad for my case.
Yeah, right.
And Irreverent D impersonates a judge.
You didn't know till the day before trial that you had a conflict?
Now, sit back and take a listen as Bob and Irreverent D talk law.
And I love nothing more than to chase down little legal rabbit holes into things that don't matter to anybody but other lawyers.
That reminds me of like what I tell people who say, I'm thinking about becoming a lawyer. Right? And I tell them, I say, okay, now listen. The single most important thing that you can do for yourself is you can get an LSAT prep book. So the LSAT prep book is the book that you study to take the test to be a lawyer, right? And in that book, there are these logic
questions,
games, logic game questions, and the logic game question goes something like this. There's a table, and Alex can sit next to Betty, but Betty cannot sit next to Charlie, and Charlie can only sit across from Daniel.
Right.
Where does everybody sit? Right.
If you find that fascinating.
Exactly.
And exhilarating.
If you're like, oh my God, I have to know where Charlie can sit, right? You will be an absolutely awesome lawyer. If the other reaction is, oh my God, I will never get this time back from my life. I could care less where Charlie sits. Well, yeah. Just stop right there. Don't go to law school. Don't take the LSAT. Save yourself a lot of trouble.
The problem with law, though, is you have all these little nuances of things that can happen.
Right.
And I run into the problem of when I'm prepping for a trial, of prepping and re-prepping and rewriting a question, and rewriting a sentence and rewriting a question. And then the night before trial, I have to do it all over again.
Anyways.
You go back through and you redo, and you can constantly tweak and do this because there's so many different outcomes that you got to kind of be willing, you got to do some of it just off the cuff because you don't know what the officer's going to say, and you don't know what all the person testifying is going to say. You think you know. Right. You're never supposed to ask a question you don't know the answer to.
God, how many times have you done that?
I had somebody not too long ago that I prepped them prior, talked to them, get them on the stand. I asked them the question. I was like, so your son was at your house on Thanksgiving and his wife was not with him. Is that correct? And she goes, and she swallows.
Oh, God, no. Oh, no.
And she says,
you hate it when that happens.
She says, I just can't lie.
No.
And I was like, nobody's asked you to lie.
Oh,
why
gosh.
are you doing this in
no.
court? She's like,
I know you really want me to say this, but I just can't lie.
I was like, wow. So, a lot of times, I'll have them, in this particular case, I didn't have them write out an affidavit and sign it because we just didn't have the time. We went to court pretty quickly.
Things happen. Yeah.
Normally I'll have that affidavit. I'll be like, remember coming to my office and you signed this piece of paper and you said blah, 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 blah.
Yeah.
But I just totally stepped in it.
No.
And I'm like, I look back at my client, I'm like, this is when I tell you don't lie to me.
God. Yeah. So how do you handle that? I've seen so many different, we were watching the Lincoln Lawyer, which is a great show on Netflix, right? And I was telling my wife, oh my gosh, there's so many things in this show that are actually really do happen. This is one
pretty
of those
realistic in some things.
Yeah.
Right?
Anyways, but I always wanted to ask a criminal defense attorney, do you ask your client if they did it? You don't, right?
You tend to stay away from that.
Right.
You tend to ask the question. So it's very important as to whether or not the state can prove that you were inside the house on this burglary charge.
Right.
So is there any possibility that they're going to find your fingerprints on anything inside the house?
Right. You would want to know the answer to that question.
Right. And they'll say, no, shouldn't my fingerprints shouldn't be inside that house. Or they'll say, well, I've known Jimmy my whole life, and I've been over to Jimmy's house a bunch of times.
Right.
And so there may be something in there with my fingerprints on it, right?
You'd want to know that.
Yeah, because, I mean, I don't want to step in it. I'd rather know before court than to go in there and step in it in the middle of court. But I think the question is, can you knowingly put your client up on the stand and have them lie and perjure themselves? And you can't. You're not supposed to.
You cannot do. You absolutely cannot.
And in fact, I've had clients that say, well, I'll just tell them this, this, and this. I'm like, you've already told me that's not true.
Now I really can't do it.
Right. Well, I want to testify to that. You can't. I can't let you. Well, now me and the client have a problem. And
You've got a conflict.
I'm like, no, you can fire me. I said, but it's your choice whether you testify or not. So I can't keep you from testifying.
Right.
But I can't knowingly allow you to lie. And so I had one case one time when we pissed the judge off bad. I was like, Judge, I have a conflict. I got to withdraw. And the judge's like, you didn't know till the day before trial that you had a conflict? I'm like,
God. Look, I literally cannot get into it.
I can't talk to you.
You can't even talk to the judge about it, right?
I can't explain to the judge what's going on.
Yeah.
So the judge is just pissed. He thinks I'm just unprepared.
He thinks that you're making it up.
Right. I can't tell him what's going on because then I'm divulging my clients. So I have to fall on it, right? I have to fall on the sword with that. God. And so that's because, you always see movies where they're like, say this, blah, 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 blah. Well, you're not really supposed to do that. Now, if my client tells me some crazy story, it's their crazy story. If they want to.
But it's not my job to decide whether it's true.
I'm going to say this is what happened. The space aliens came down and grabbed him. And they took him up and probed him. When he came back down, he shot everybody. Right. Now it's my job to say, hey, nobody's ever going to believe that.
To your client.
Right.
Yeah, you're not going to say that to the jury.
Right. I'd rather you not go with that. But at the end of the day, had a client one time on a case where it was a ID case and they had a bad ID that said,
Bad. Wait. Does that mean like a fraudulent identification card?
No. It was a ag assault, ag battery, attempted murder type situation. But the person the witness that saw the person leaving.
Right.
Saw a white male.
Okay.
I represented a black male.
Okay.
Okay.
So could not have been your client.
So they had other evidence, other circumstantial evidence to lead to it. But the client demanded that he would testify, even after I advised him.
Not a good idea.
Just be quiet, sit there. I want them to know. Okay. No. And the DA down there was on the case and just did a brilliant job dissecting him on the stand.
On cross-examination.
And there was, I'm objecting and doing everything I know how.
Song and dance. No.
Well, I'm objecting just because she's doing a good job. Like, just stop, please.
What's that movie? I object, Your Honor. It's bad for my case.
Yeah, right. And, and it resulted in what I feel was a turning point of the case. It resulted in a conviction. It went from having reasonable doubt,
right,
to now
a bad ID.
But now he just sounds like a liar. He didn't come across as truthful. Everybody thinks they're human lie detectors, right? Mm-hmm. And so it resulted in a conviction. And so, and I had a choice. I could have just withdrawn from him not following his attorney's advice. But I'm in it at this point, and
right.
They even make the client stand up and say, hey, you have this right to testify. Do you want to give up that right? And I'd said, you stand up and you say yes, and you sit back down. He's like, I want to testify. That was it.
Oh, God. I hate it. You
got to be careful what you ask for. You just might get it.
Well, you ready to tackle the news?
Let's do it.
And now, the news.
All right, so this is a reported case. So some of these things that we're covering are news items that are interesting in the news, and sometimes we look at the Court of Appeals opinions and we say, hey, that's really interesting. And this one was really interesting to me because...
So just for laymen who don't practice law.
Oh, yeah, right. What is that?
Right. So you have your your statutes or
Right.
your written laws that are in the books.
That's right.
That are passed and put out there.
Mm-hmm.
And then you have what we refer to as case law,
Right.
which is where the higher courts have made a decision
Right.
that affect how we look at those statutes. In
That's
fact,
right.
some statutes may be found to be unconstitutional.
That's right.
So even though they're still in the books,
Mm-hmm.
they're not enforceable anymore. Correct?
Because a judge has been asked to give an opinion about its constitutionality, and they
Right.
said,
So
no,
this
this
could
is
deal with
unconstitutional.
How we deal with evidence, or how we deal with witnesses, or what it takes to prove a case. And this is the court coming in and basically clarifying those issues.
That's right.
Right. Okay.
Right. So ultimately,
So this is a Court of Appeals case out of what court?
so this is the Georgia Court of Appeals.
Okay.
Right? And it has to do with a medical malpractice claim. So here's what happened. This guy went into the hospital where he had symptoms that could have been seen as having a stroke.
Okay.
Right? So stroke is when there's something that happens in your brain that causes an infarct, what we call, or a constriction, and it stops the flow of the blood in your brain, and then it affects your whole body, or usually affects like one side of your body, right? What we know now with modern medical advances is that there's this drug that you can give a person
Right. If you catch it early.
if you catch it early.
Right.
So I don't know, Dwayne, have you seen this? Where
The stroke buster or stroke blocker, or what do they call that?
yeah, it's called troponin, right? So what they can do is it basically just kind of opens up your blood cavities to make sure that stuff doesn't get constricted. I'm not a doctor. That's my layman's
It's like
understanding.
throwing some Drano in there.
It's like throwing some
Cleans it
Drano.
up for a
Exactly
little bit.
right. Now, I don't know if you've ever seen this, but just recently I saw a billboard on the side of the road that says, "Know the signs of stroke."
Right.
Right? And the reason that billboard is up there is it's a public service announcement to say, listen, if you can identify the signs of
We
a
can
stroke.
avoid all these major debilitating factors.
That's right. And if you have a stroke, it's bad.
Right.
Like, I mean, it isn't always permanently bad, but like any time that your brain and your body is starved of oxygen because there's something going on with the blood vessel, bad, generally bad, right? So here's what happened. This guy goes to the hospital. A bunch of people thought, maybe he was having a stroke, but the doctor did not.
Okay.
And was not, according to the complaint, the doctor was not paying attention to his symptoms.
Right.
And because he was not paying attention to the symptoms, the doctor did not order this thing to be given to him.
So
Right?
now we've got something that can be fixed or prevented, and we've got
That's right. Should have recognized this as stroke symptoms.
right.
Every nurse is drilled into recognition of this. Just missed it, right? And so they didn't get done. So blah 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 blah. They sue the doctor. They sue the hospital,
Right.
right? And in that it's kind of a long-winded explanation, but it is good. It is important. They sue the doctor. They sue the hospital. In that circumstance, when you file a lawsuit for malpractice, you have to have a medical opinion from a treatment provider that is in that same type of provider that says this is malpractice.
Right. So it's not just like a car wreck where somebody caused an injury and you can just go file a lawsuit.
That's right. Yeah.
This, you have to have somebody else that's a doctor with the same credentials in the same
Essentially.
area
That's right.
say that, yes, I've looked over this and I agree there's a problem.
And
Otherwise, they can't even file the lawsuit.
You
Or if they
cannot-
file it, it's going to get kicked out, right?
that's right. That's
Okay.
right. You would be wasting your $300 in your crown.
So if I say, hey, the doctor did me real bad and I file it, that's not going to get anywhere if I don't have this affidavit of another doctor attached.
That's right.
Right.
And eventually, now that's just to get in the door of filing the lawsuit. Eventually, you as a plaintiff have to have a medical opinion that says, and you know what? Because of this happened.
Right. because of your negligence, here's the cause, and now we have an injury.
And now we have an injury. That's right. So this comes up with my cases all the time, where I've got a client, for example, who is injured in a car wreck, and they have a herniated disc, right, and in their lower back, and my client is convinced, well, I didn't have this herniated disc before this, right? And now I've got this herniated disc, ergo, right?
Must be from the accident.
Had to have been from the accident.
Right.
Right? And then...
And the insurance adjuster says, no.
Negatory.
It would have happened anyway, or something else caused it.
Nearly. What they'll say is, oh no, honey, they have degenerative changes in their back. That's what's causing the pain. Right. Or this herniated disc has been hanging out for a while. Right. You can't
it's an old herniated disc.
Old
had it for years. They just didn't feel it.
We had that
accident.
Yeah, that's right. We had that dated.
Right.
there was a phenomenon where, I mean, it was probably 10 years ago, where there was this vendor that was going around saying we can carbon date or whatever, like we can tell how old a herniated disc is.
An injury.
Yeah, we can tell how old a herniated disc has been hanging around. That lasted for a year or two before everybody was like,
tell how fast the car's going by the way the Johnson grass lays down on the side of the road when it passes.
That's right. You got it.
Yeah,
you got it. So what most people don't understand, though, is that you can't get, even outside of a medical malpractice case, you can't go in front of a jury and testify, I know I have a herniated disc because of this car wreck.
You're not a medical professional.
You are not qualified. You could believe it. You could be convinced of it. Doesn't matter, right? Now, there are some exceptions where a jury could come to the conclusion that you broke your femur. Right, because this car came and T-boned you, and you didn't have a broken femur before then, right? That would be something like you wouldn't necessarily need a medical doctor to say, yes, the car. You
don't have to have a camera on the leg at the time it breaks.
Yeah, right, exactly.
There can be some circumstantial evidence that leads to the results of this is what caused it, right?
Yeah, but absent that, like in most circumstances, you need a doctor to say,
sure,
yeah, okay, this is what happened. Here's the problem. That the defendant is going to get a doctor that says, "Oh no, this was already there, or this wasn't the thing that caused the problem," right? And
he probably does that on hundreds of cases per year in multiple counties and multiple jurisdictions. But you're not allowed to really go into all of that, though.
You can.
Go into some of it, right?
You can go into if there's a doctor that all they do is testify in trials on behalf of defendants. Right. If they're testifying in trial, I can ask them, "Isn't it true, doctor, that all of your testimony has always been for defendants?"
And isn't it true that you never actually looked at my client or met with him or did anything other than review these records?
That's right. Yeah. So, I mean, there are things that you can do, but there's nothing, and this is another thing, another truism. There is nothing in the world that we can do to prevent them from arguing it. Right? They're going to argue it. We just have to be better at our argument. Anyways, so here's where the real muddy stuff gets. And that is that doctors are really, really reluctant, unless they're paid experts. Right. They're really reluctant to give a medical opinion about this caused this. Right. For example, here's how it would go. Right. I would say, doctor, now, did you do an MRI? Yes, I did an MRI. Right. What did the MRI show? Go ahead.
MRI showed that we had a bulging protruding disc between C7 and C8.
Okay. So was that bulging disc caused by the accident?
Well, that's where you get a problem.
That's where you get a problem. Why? Why is the problem there?
Because he doesn't want to say that he can't say 100%. That's
not even 100%. He can't even say. Right. Here's why. Because the elephant in the corner of the gorilla, right, is in the corner of the room, is that all of us are walking around with herniated discs that don't hurt, all the time. You're standing here, you've got a bulging disc in your back. I promise, if we did an MRI right now, you have 3 or 4 bulging discs that do not bother you.
So are you saying that you take that MRI and use it to deceive people? Because you're always picking on me.
Obviously not.
Right.
Obviously not. But so then the next question
issue is that it wasn't hurting them before, right?
That's
They didn't
exactly
have
right.
pain.
That's right.
So yes, normal aging may have caused something, but they weren't suffering from it
That's right.
until the event happened that caused the pain to move forward, right?
Exactly.
Right.
Exactly. So in that circumstance, I don't ask the doctor. First of all, I can get a doctor to pretty much say whatever I want him to say. I'll give you an example. Doctor, I want you to assume that these 3 things are true. 1, my client didn't have a broken leg before he fell from the building. 2, he fell from the building. 3, upon falling from the building, he was found to have a broken leg. Do you think the fall caused him to have a broken leg?
Assuming those 3 facts that you've given me, yes.
Exactly.
The fall caused the broken leg.
Now, doctor, I want you to make here's a new hypothetical question. I want you to assume that he already had a broken leg and he had already been walking around on a broken leg before he fell, and then assume that he fell, and then assume that when he fell, he was found to have a broken leg. Can you say that the fall caused him to break his leg?
I can say 100% the fall did not cause the broken leg because he had it prior to the fall.
Exactly.
Right.
All I have to do is set up the hypothetical question exactly how I want him to answer, and I know exactly how he's going to answer. So the best that we can do with doctors, and understand, like I sometimes get frustrated
And
because
this is where you hear lawyers come back and say, had this great case, we did the depot, and the doctor's
just like,
laid a giant one on top of my case.
right?
And now
I don't know. Yeah.
Now I'm out $100,000,
Right.
and I don't know what to do with this case because he's turned it into dog crap.
Because he turned it.
Yeah.
But it's all about positioning the question.
Right.
Right? Because ultimately, all I need the doctor to say is, yeah, it probably happened like that.
Right.
Right? Probably happened like that. Good enough. Anytime that you are conveying to a doctor, or a doctor thinks, I have to say for certain it happened like this, you have lost. Doctors will not do it.
Well, and this is also the difference in between like criminal and civil burdens, right?
That's right.
So if we're looking at it from a criminal standpoint, where we've got to prove guilt beyond a reasonable doubt,
That's right.
right? We've got this huge gap. And so some of this evidence that y'all might allow in a civil case might not even come in a criminal case. We may be able to keep it out, right?
Yeah, in a civil case,
But in a civil case-
we're not doing this.
Right.
We're going like, okay, it just has to be like this,
Right.
It just probably was like this.
And that's why you hear like, oh, they won their civil case.
But they lost the current,
Right. They
the
got,
OJ thing.
They got
right?
$10 million on their civil case, and then he won his jury trial on his criminal.
Yeah.
So
That's
one
right.
jury found him guilty and one jury found he wasn't guilty, and it's because of that difference
That's
between the weight of the evidence and the burden.
That's right. And really the best that you can do when you're talking to doctors is you have to you essentially make it into the credibility of your client, right? So what I typically say is, all right, doctor, I'm not going to give you one of these crazy hypotheticals like you heard before, right? I'm just going to ask you to assume this. I want you to assume that the herniated disc already was there. And then I want you to assume that it wasn't symptomatic. And you can assume that based on the fact that my client didn't get any medical treatment.
Never had any treatment.
Never had any treatment.
Shots, injections,
Never
surgeries,
didn't go to a chiropractor or any of that kind of stuff. Did not have any of that. Then they had this car wreck where you can see the pictures here, right, where the car is completely, totaled, right? And then they had lower back pain. Would you say that the mechanism of the injury is consistent with the lower back pain as caused by that herniated disc?
Yes.
Right?
Right.
Of course. But what that relies on is that the jury has to believe my client.
Right.
Right? It's something we push out to, okay, well, at some point there's a pay the piper day where where you have to be in trial and your client has to be in front of the jury and the jury has to believe them. I didn't have problems with my back before, and then I did have problems with my back, and then the doctor's opinion goes neatly into place. That's right.
Now, when you're looking at like going prior to trial, do you ever talk with your clients and be like, look, because I have this happen a lot on criminal side, like, look, you and I have got to like each other when we walk in there. You can't be, because they're so upset with the system. They're so upset with how long it's taken. They're so upset with how it's been going. And you have to say, hey, look, if you go into this courtroom with this terrible bad attitude, I understand you're mad at the insurance company and that you're mad that you've lost your life and that you've lost your livelihood and that you're in this wheelchair. But if you don't, if you're not likable to this jury, you got a problem. Do you ever have that conversation?
I have that conversation in two parts.
Okay.
One is this. I say, listen, understand that I'm a good arguer. Really great. Okay, I can sell a lot. But ultimately, the only thing that's actually going to matter is whether the jury believes you.
Right.
Right? No pressure. It's just that the jury either believes you or they don't believe you. Right? And I can jump up and down, and I can argue until I'm blue in the face, and it will not amount to a hill of beans. If they don't believe you, they don't believe you.
Right.
Right? The second thing I say is, if you can't figure out how someone could not believe you, how you have not done enough figuring. Right? Or if you can't figure out how you can lose your case, you have not done enough figuring. Right? There's always a way to lose. There's always a way to lose a case. And then the third thing I say is, listen, if you're going to testify, understand they have to believe you. But, when you're doing that, if you go in and you're acting righteously indignant, right, and you're like, I demand justice, right? Like, I've never been in a trial where that attitude
win
was won
or
out.
Lose, justice was served, right? It might not be what you wanted.
That's right.
But at some point, that was justice. What the fact finder decided to find.
That's right. That's right. It's kind of like what was it? Milton Friedman says, all debts are paid.
Right. That's right.
One way or another.
One way or another.
One way or another, they're always paid. Anyway, so that's the long and the short. On causation, you always have to have a medical opinion that says, yeah, this was caused by that.
So what happened with this case? Was there not causation there? Were they not able to outline it?
Yeah.
How did they end up in the Court of Appeals?
Yeah. Well, the news item.
Right. Around we go.
And there we go. So what had happened was, right, the plaintiffs got this expert that said something along the lines of, listen, the doctor should have recognized these symptoms, should have prescribed the medication, and because they didn't prescribe the medication, he had this stroke.
Okay.
Or probably had this stroke. Or could have had this stroke. Then the hospital got their own expert, and they say, whoa, he was going to have the stroke no matter what. Doesn't matter, right? The failure to do this, he was already too far into it, wouldn't have mattered, right? And so the Court of Appeals had to
So this negligence didn't cause this injury.
Yes, exactly.
Causation, right?
Causation.
Right.
It has to have caused it, right? And so what the Court of Appeals did was they looked at, the trial court looked at the opinion from the plaintiff's doctor and said, he didn't exactly say that it probably caused it. He said that it could have caused it, or words to that effect.
Right.
And that's just not strong enough, right? Doctors will not say it definitely did, right? Almost as a rule. They have a really hard time saying it probably did. Doctors always want to say, yeah, it could have, right? And for a plaintiff, yeah, it could have is never good enough.
Wow.
Right? It probably did is just good enough, right? But it could have not good enough. So that's why I got kicked out, and that's why the Court of Appeals said, yeah, that's right. Could have is just not good enough. True story.
So when you're reading over those expert opinions, and you got to really make sure your expert knows what they're talking about, but two, that it's clear that they're answering the question that's presented in front of them to an extent that it can survive trial or summary judgment.
Yeah, I mean, I don't know who this particular expert was, but, that's something that we always struggle with as plaintiff's attorneys is, well, do I use the doctor who is treating them
Right.
and have this wild card of, God, I don't know what he's going to say?
Or do I bring in the guy from Harvard?
Right, or do I, exactly, do I bring the guy I know exactly what he's going to say, but, there's baggage there because, this guy didn't treat him.
Right.
So, for the life of me, there is no right answer to that. You just, you have to do the best that you can and figure it out as you go along.
Now, just for people that don't practice and aren't in the law, a lot of these cases like this are contingency fees, right?
Right.
Which means you're not paying anything to the lawyer up front.
That's right.
So the lawyer's fronting all this money,
Right.
paying for the expert, paying for the time.
And the time.
Travel, all that kind of stuff. And he gets a verdict like this,
Bupkis.
0.
You know what bupkis means? Goose egg.
Goose egg.
You got not just goose egg. It would be negative, right?
Right.
Because
Right, he's out the $100,000 or $200,000 that he put into the case, and he didn't get a verdict at the end. So
Yeah,
I just
up.
want people to understand that because, when we take on these cases on a contingency fee basis,
There's risk.
There's risk involved,
Yeah.
and at the end of the day, there's no magical place that money's coming from.
Right. Coming from my pocketbook.
Right. I mean,
That's right.
and it depends on the size of the firm and the strength of the firm. He may be going and getting a job next week because he can't pay the bills.
You-
after
the
that.
plaintiff's attorney that lost that? Yeah.
Right.
It could
I
be.
mean, I don't know this guy, but
Yeah.
I'm just saying.
Well,
that-
it's an interesting point. Well, good Lord, we're running out of time. We haven't even got to the other sections. Anyways, it's an interesting point because whenever either one of us has a client that wants to talk about a medical malpractice case, I would listen, and then I say, I'm going to say this very careful. I want you to listen to it very careful. You have a case. I just don't know if you have a case that I can afford to work on.
Right.
Right? It's not about whether you have a legal case. You do, right? The question is, financially, can I afford to take it on and with the risk? Yeah. And unfortunately, part of that also is, what are your damages?
Right.
Right?
If you've got a medical malpractice case and your damages are $5,000,
it's really hard to justify
I
spending
can't
$20,000 on an
$20,000
expert.
to get an expert in here to say, hey.
And you're going to need an expert.
Right. I mean, he messed up,
Yeah.
but there's not enough damages here.
There's one notable exception to that. And that's kind of this factual scenario. I went into the hospital to have my right leg amputated. Right. And they amputated the other leg.
They marked the wrong leg.
They marked the wrong leg.
These
Right.
are legit cases.
Generally speaking,
Right.
you would not need an expert to to say the
or
doctor
even a
cut
huge
the wrong leg off.
amount of, special damages going forward.
Medical bills.
Right, yeah.
Right. Yeah, I mean, that would be pretty obvious. But, likelihood also is that case is not going to go to trial.
Right.
Right? They're going to work that case out.
Yeah.
We're going to have to skip over some of this. Let's take, should we do Can I Sue for that or Mailbag?
Let's do the mailbag. Let's answer some questions.
It's time to dip into the mailbag.
All right. Okay, this is a quick and easy one for our constitutional law expert, a criminal constitutional law.
In here?
All right, so is it wrong, unconstitutional? Is it right that the police can search me and give me a field sobriety test at a checkpoint?
Okay. So.
This isn't quick and dirty, is it?
No, it's not quick and dirty.
Okay, all right.
So. In
was
Georgia,
wrong.
the laws have changed significantly over the last couple of years, and I'm not going to go into all the cases.
Oh, wait, can we pause for just
Sure.
a second? Just to clarify. First, clarify terms. What are they talking about? They're talking about you're driving down the road,
Right.
and the police have
Come up on a roadblock.
there's a roadblock. They're stopping everybody.
So we don't have any bad driving.
Right.
We don't have any open signs of intoxication to normally stop you.
They're stopping
and detain
everybody.
you. They're stopping everybody.
Right. Okay.
So they're going to be.
How can they do that?
So as long as it's minimal, as long as it doesn't take a long time, as long as
Okay.
they don't back up traffic, they can't go block off 75 and spend all night.
And have the traffic back up to Dalton. Right.
It has to be minimal. As long as they do everybody, or do every other body, right? Or do everybody and then stop for a minute and let everybody through so they don't back up traffic, as long as they're being fair
Okay.
to everyone. And we're not just singling out and just stopping, white males with cowboy hats, right?
Right.
As long as we're doing everybody, then they can do this, they can check for, as long as it's outlined by their supervisor where they're going to be and approved and it's exactly what they're looking for, they can do these roadblocks, okay? They're going to ask for your license and your registration. Now, you don't have to answer any questions, right? You can say, lawyer, I'm not answering the questions. I'm not going to hand you my driver's license. I'm not going to hand you my... But this is where we get confused in between a request and a lawful command, right?
When we were talking about that earlier,
Yes.
were we on, or that was before we were on?
I don't think we were on it.
I don't think we were on. Okay. Okay. Go ahead.
So you get this request versus a lawful command. Well, they're allowed to ask for your license and registration. If you choose not to give that to them, then probably what's going to happen is they're going to knock your window out and drag you through the window so that they can see. Now, the officer may have violated your rights by doing that. I don't know.
Okay.
Okay? But
Can I pay you for your legal opinion about that?
But if it could have been incriminating, right? Like,
Right.
I've got a suspended driver's license, I have no registration, then I have an absolute right to say I invoke the fifth, okay?
Okay.
Now, if the officer says, well, I'm commanding you, or I'm ordering you
Okay.
to step out of the car.
That is not a request.
Right.
Okay.
Because I need to ascertain, I need to detain you so I can figure out who you are, why you're here, and all that kind of stuff. Then when I don't follow that, then I have a problem. That's when people get in this mess with requests versus lawful commands.
Okay.
So, yes, they can stop you. Yes, they can check your license and registration, as long as it doesn't take up a whole bunch of time.
All right. I'm making a note. We're going to take up request versus lawful command, either the next episode
Sure.
or the episode after that, because that sounds like it's going to be
Well, that's how a
quite
lot
bit.
of people get themselves killed.
Okay. Well, then we definitely need to cover that.
Right.
There's a can I sue for that? I'm just going to plug this in, and we're going to cover it next episode. Jim from Riverdale says, can I sue the landlord for unreturned deposit when we come back in 2 weeks? We will cover that answer.
All right.
All right. Thank you for joining us. Make sure you guys subscribe and like us.
Like us.
Like us.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.
Like me.